All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you. Please be seated. Good morning. I'd like to welcome council and any viewers we have here today. We're here for second case this morning. We're reestablishing oral arguments. Today is the first day of in-person oral arguments we've had since the COVID crisis, and we appreciate council being here. We have instituted certain protocols for your safety, and hope that those are not too inconvenient. During oral argument, please feel free to remove your mask. Certainly probably helps us to understand your arguments better. We'd also just encourage you to feel free to give us any suggestions or comments you have about the COVID protocols. We're just trying to make it as comfortable and as safe for everybody as we can. At this time, I'll call number 07-20-00145 CV Roberson versus Shackelford here today for oral arguments. Counsel for the appellant.
Mary Kathleen Davidson, the appellant Jerry Roberson.
And Davidson, are you ready to proceed?
I am.
And counsel for the appellee.
Good morning, Your Honors. Benjamin Garcia on behalf of Mr. Shackelford. We are present and ready.
Ms. Davidson, you may go ahead and take the podium. Getting set up by way of making you hopefully a little bit more comfortable. We always kind of give our cases nicknames behind the scenes when we're talking about them. Obviously, this case has gained the moniker of the dumpster case. The dumpster. So I'm not sure that that's really a good omen, but we'll allow you to proceed with that. Is that good?
Good morning.
Good morning.
May it please the court. This is an appeal of a final judgment preceding a bench trial in a negligence case. The court should reverse the final judgment for 4 reasons. First, it was error to hold Jerry Robertson individually liable. Second, Mr. Shackelford's expert testimony on negligence and proximate cause was conclusory, speculative, and therefore no evidence. Third and fourth, there is legally and factually insufficient evidence of negligence and proximate cause. In the court's conclusions of law, it held that because Mr. Robertson failed to timely respond to properly served requests for identification of potential responsible third parties, that it was irrelevant as to whether Mr. Robertson secured labor to clean up the property in his individual capacity or as an agent of JQ Long Roofing. The trial court also held that because of this failure, it was irrelevant.
Hold on, just a moment. The timer is not advancing. Bobby? You got any suggestions?
I'll bring in the shot clock operator.
The shot clock. It's
You want me to start all over?
yeah, it's going. You're fine. Well, okay. I'm sorry. Pardon me for interrupting you.
The trial court also ruled that it was irrelevant as to whether the 3 workers were working as independent contractors or employees. This is not the law. Mr. Shackelford must prove that Mr. Robertson is individually liable. And as soon as Mr. Robertson filed his general denial, the merits of plaintiff's case was placed into issue. And Mr. Robertson may still challenge the proof of plaintiff's right to recover in any capacity alleged. There was legally and factually insufficient evidence that the three workers were working for Mr. Robertson individually on the day in question.
Isn't there some evidence in the record that Mr. Robertson personally went out to inspect the fire in the barrel at one point?
So what happened is he was driving by and he saw the three workers and he saw them putting out the fire. He didn't see them burning. So he went in, he went by, put the fire out, and then he double checked the barrel to make sure that the fire was out.
When you double checked to make sure that the fire was out, isn't that some evidence of control?
It could be evidence of, well, no, because he was not necessarily directing the workers who light the fire. He was looking to make sure, he was just looking on his own to make sure it was out.
Is there any theory or evidence presented at trial that Mr. Robertson was individually negligent on his own for failing to take additional steps beyond the supervision of the other three people?
No, this case was tried on vicarious liability. And no one has alleged that Mr. Robertson individually lit fires in the barrel. There was, when plaintiff originally filed his petition, they did have a direct theory, a failure to supervise. However, at trial, he said that he was trying it on vicarious liability and alter ego. There is legally and factually insufficient evidence that the three workers were working for JQ Long, or excuse me, for Mr. Robertson in his individual capacity.
Any evidence as to how they were compensated? Were they paid by the company or by Robertson?
They were paid by the company, and in fact, the trial court's findings of fact says that the three workers were paid from a JQ Long roofing bank account for the work in cleaning up the property. And those checks are in the record. The three workers, they were cleaning up in a right of way adjacent to property that Mr. Robertson owned, but was leased to JQ Long Roofing.
Is the nature of that work, what they were doing, consistent with the roofing business?
It was part of housekeeping. And it was for the benefit of JQ Long Roofing. On that property, you will not find Mr. Robertson's residence. You won't find any residences there. What you will find is the JQ Long Roofing shop. The tools that the three workers used. Those were tools that were either provided by Bernardo Ortiz, who was one of the workers, or they were provided by JQ Long Roofing.
You said you thought that all of this evidence was performed within the functions of JQ Long Roofing. I recall, I think there was evidence in the record that the area they were working in that was cleaning up was actually sort of the alley area. Was it not?
It is an abandoned railroad right-of-way. It's a 20-foot wide alleyway that is adjacent to the property on which JQ Long Roofing sits. And they were cleaning up in the alleyway because of the overgrowth there and the prior vandalism. And so it was for the benefit of JQ Long Roofing. Now, there was some testimony that three workers would occasionally check on Mr. Robertson's farm animals, or they might mow his lawn. And that might well be true. On one day, you could work for one person in one capacity doing one job. And then on a different day, in a different time, at a different place, You could work for another person or another company doing a different job. So whether they milked his cows or mowed his lawn on the weekend doesn't change the fact that on the Friday afternoon in question, they were working for the benefit of JQ Long Roofing. With that said, the trial court abused its discretion when it ruled that the issue of alter ego was tried by consent. Mr. Shackelford did not plead alter ego. And so therefore, there has to be not only evidence of the issue, but evidence of a trial of the issue. And so when Mr. Robertson's counsel was asking the three workers, who did you work for? What type of work did you do? What did you do? Who supervised you? That all went to the issues of, did they work for JQ Long Roofing or Jerry Robertson? Were they independent contractors or were they employees? There was no need for Robertson's counsel to object until Robertson was asked about insurance. However, even if the court were to find that alter ego had been tried by consent, there's legally and factually insufficient evidence that JQ Long Roofing and Jerry Robertson are one and the same. And in order to pierce the corporate veil, not only must you find alter ego, but you must also find injustice in the context of alter ego. A party.
What about the individual employees? How did they testify on who they were working?
So Bernardo Ortiz testified that he was a subcontractor for JQ Long Roofing. Sammy Ruiz, at first when he was asked, how do you know Jerry Robertson? He said, I work for him. However, he later clarified that Bernie Ortiz was his boss. And he said that during the time period in 2013 that he primarily worked for JQ Long Roofing. Pedro Pena, at first he said that he got paid by Jerry Robertson or JQ Long Roofing. However, he identified a check from JQ Long Roofing as the check that he received. And he also said that JQ Long Roofing was probably his sole source of income in the year 2013.
When we're analyzing the evidence for legal and factual sufficiency, do we get to take into account the witnesses' clarifications or changes of position, or do we only have to look at the evidence that's in light most favorable to the judge's findings and conclusions?
So for a legal sufficiency challenge, then you must look at it in the light most favorable to the conclusions. Although the judge concluded that it was irrelevant as to whether they were working for JQ Long Roofing or Jerry Robertson. However, for a factual sufficiency challenge, the court must examine and look at all the evidence, and no deference is given to the findings. So, with respect to alter ego, there is no evidence that Jerry Robertson diverted company funds for his own use. No evidence that he undercapitalized JQ Long Roofing. No evidence that he personally promised to financially back the corporation. No evidence that he paid corporate debt with personal funds. What the evidence does show is that the property has been leased for 75 years before Jerry Robertson even owned the company. JQ Long Roofing has insurance. It has its own bank account. It owns its own roofing equipment. It does have annual meetings, however, and with meeting minutes. Now, Mr. Robertson did testify that he personally owned the cars. However, there was no testimony as to whether those were leased to JQ Long Roofing or not. And finally, a party can't be liable for corporate obligations merely because of shared finances. But most importantly here, there's no evidence that Mr. Robertson abused the corporate form to commit injustice. No evidence he committed crimes, frauds, circumvented statutes, monopolized the corporation, or used the corporate form to evade existing obligations. Therefore, there is legally and factually insufficient evidence of alter ego. Moving on to experts. Mr. Shackelford designated Philip Mize, the Plainview Fire Marshal, as an expert witness. Rusty Powers, the Plainview Fire Chief at the time, also testified for the plaintiff as a fact witness, but he did give some opinions concerning Mr. Shackelford's negligence theory. The expert testimony is speculative and conclusory, and therefore constitutes no evidence. The testimony is based on assumptions that controvert the actual facts and rely on analytical gaps. Both Mr. Powers and Mr. Mize testified that a 5-gallon bucket of water would not be sufficient to extinguish a 55-gallon barrel that was 3/4 full of ash. However, at trial, the 3 workers were shown side-by-side photos of the southwest barrel and the southeast barrel, which was determined to be the ignition point of the fire. All 3 workers said that the barrels they used were not as full as the southeast barrel. All 3 workers said that the barrels they used looked more like the southwest barrel. And there was no testimony concerning how much water it would take to completely burn out and cool a barrel that was less than 3/4 full of ash. There's no testimony concerning how much water it would take to burn out and cool a barrel that was 1/2 full of ash, 1/4 full of ash, a mixture of ash and leaves. Also, there was no testimony concerning how long a barrel would take to fully burn out and cool if it was less than 3/4 full of ash. Would it take an additional 2 hours, 12 hours, 24 hours, 2 days? Mr. Powers and Mr. Mize do not say. Their testimony is also conclusory and speculative because they fail to rule out other plausible causes. Mr. Mize was aware of 2 other fires that occurred in the right-of-way approximately 8 months earlier. Mr. Powers spoke with Mr. Roberson the morning of the fire, and Mr. Roberson told him about damage to his fence, and he said that kids could have relit the fire. However, Mr. Powers did not even investigate whether kids or another person might have committed a fire. Why? Because he said he didn't see any drag marks on the ground. And the southeast barrel that was 3/4 full was too heavy for him to lift. When Mr. Mize was asked if he investigated this alternate theory, he said he didn't even talk to Mr. Robertson. He just relied on Mr. Powers' report and later a police report as confirmation that the 3 workers were burning leaves in the barrel in the alleyways.
Let me ask you a question related to that. This notion that the fire may have been caused by something else or someone else. Is that an affirmative defense? Is that an inferential rebuttal issue? What is that?
It is not an affirmative defense. Plaintiff has the burden to prove his case, and the case law says that experts must rule out other plausible causes of a fire, or else their testimony is speculative and conclusory. And the problem with Mr. Powers' no drag marks reason is, first of all, he is assuming that the barrel was 3/4 full before the Monday morning fire was started. It might be too heavy to pick up when it's 3/4 full of ash, but it might not be too heavy when it's 1/2 full or 1/4 full. But the bigger problem is if we were to assume that the 3 workers started a fire in the southeast barrel on Friday at the exact same location where it was found on Monday, then Mr. Powers and Mr. Mize failed to explain why another person couldn't have started a fire in the barrel at the exact same place. The right-of-way is outside. It's not enclosed to the north. Someone could have easily walked onto the property and started a fire. In fact, they had started fires there in the past. So therefore, their testimony is conclusory because they fail to rule out other plausible causes.
Now, what testimony was given for this hearing of those possible causes?
Could you repeat that?
Well, you said that the plaintiff had burden of establishing, that the fire was not the result of another possible cause. Was there any testimony given as to this hypothesis of a third party?
Mr. Roberson did testify that he has had multiple problems with vandalism, with people breaking into his property, lighting fires on his property. Mr. Mize admitted that there were 2 fires in the right of way approximately 8 months ago. And Mr. Powers even talked to, or excuse me, Mr. Robertson talked to Mr. Powers the morning of the fire and told him about damage to his fence, and even filed a police report about that. So they did know of prior vandalism. And also that barrel was 3/4 full of ash on Monday morning, but when the 3 workers extinguished the fire, the barrel was between about 5 inches of ash, 5 to 8 inches of ash to no more than 1/2 full of ash. So there was more ash there on Monday morning than there was on Friday afternoon.
Did any of these folks who testified as experts get an opportunity at trial to answer the question of whether they thought third parties did something?
Yes. Mr. Powers was asked at trial, what did he do? Well, he was asked, did you investigate whether or not it had started the fire? And he said, I didn't even investigate that because I did not see any drag marks on the ground. And Mr. Mize was asked, did you investigate this theory about whether kids or another person started the fire? He said, I didn't even talk to Mr. Robertson. I relied on Mr. Powers' report and later a police report that said that Mr. Robertson's 3 workers were burning leaves in barrels in the right of way. And in the report that in the fire marshal's report, he even states the men working in the area may have thought the fire, the barrel was out, but with the amount of ash in the barrel closest to the point of origin, it would have taken several days for embers to completely burn out and cool.
Wasn't there some testimony that they had to return with a fire truck several days later to?
For the southeast barrel, there was. However, on Friday when they returned, they did not take the southwest barrel's temperature. The southwest barrel's temperature was only taken one time, approximately 8 to 9 hours after the 911 call was reported for the Monday morning fire. After it, so they took the southwest barrel's temperature then, and they took the southeast barrel's temperature on Monday. But on Friday, they did not take the southwest barrel's temperature, and they did not pour any water on the southwest barrel on Friday, only the southeast barrel. And you know, this was a fire fierce enough to burn down an entire barn. The entire right-of-way was covered in debris and tin from the building. And I think Mr. Powers even said he did not find any hot spots separate and apart from the debris. And so on Friday, when Mr. Mize came back, there was still debris and tin in the right of way. We know this from the pictures that were submitted into evidence that have the date stamp of the 22nd on it. And yes, he did pour more fire on the southeast barrel, but not the southwest barrel. And all 3 workers said that the barrels they used look more like the southwest barrel. Thank you, my time's up.
Thank you, Council. You'll have 5 minutes to move on.
Good morning, Your Honors. May it please the court. Counsel. Your Honors, we were asking the court today to affirm the judgment of the trial court. This appeal is brought on 4 points. The first point concerns individual liability. I'd like to begin there. With regard to the way that this case was pled, our petition, my client's petition, alleged 2 different theories for Mr. Roberson's liability. I'd like to back up and say from the beginning, this was Ronald Shackelford versus Jerry Roberson. Individual versus individual. When the suit was filed, it was filed in 2014, May, approximately a little more than a year after the fire. My client filed suit for Mr. Roberson's own negligence, his negligence in leaving his property unsafe when there had been fires burning, negligence in the supervision of his employees, and also negligence in exercising control over his employees. When that suit was filed, Mr. Roberson was served with a request for disclosure, requesting that he disclose other potential parties, other responsible third parties, and also he was required to provide the correct names of the parties to the suit. Really basic Rule 194 stuff. He did not respond. He did not respond. There was no response whatsoever, and it wasn't until August the 15th of 2016, so over 3 years after the fire, that we first see this defensive theory really of I have a corporation. This was all done in the name of my corporation. You need to sue the corporation, not me personally. That was never brought up until limitations had expired. And there was a comment earlier that alter ego should not be applicable because there is no injustice. There is no injustice that has to be addressed. Well, if we just look at this timeline and when he brought up the fact that, hey, there's a corporation, it makes it clear that that would result in injustice. This would result in injustice if Mr. Roberson is able to hide behind a corporate shield. Also, Mr. Roberson told investigators from the beginning that he hired these men. He told the chief of the fire department who came to investigate this, Mr. Powers. He told Mr. Powers that he had hired these men. He didn't mention J.Q. Long. He didn't say these people were working for my corporation, not for me. He told the investigator from Jump Street, I hired these men. Additionally, Mr. Roberson is the owner of the premises in question. Yes, the corporation does lease the property, but Mr. Roberson owns it in his own name. He holds title in his own name. If there is a lease, he's leasing to his own company. And as Your Honor pointed out earlier, these events occurred on an area in between the two properties. A strip of land owned by neither party, not a strip of land on which the corporation is doing business, but a piece of land adjacent to Mr. Roberson and Mr. Shackelford's property, separating.
Is there a plat or a map in the record that you give a feel for that?
Your Honor, there are some photographs, including aerial photographs. In my brief, I've attempted to use some color to show where the relevant pieces of property are. And so I can't refer to a specific map or plat on the record, but I would represent to the court that my brief contains an accurate diagram. It's image 1, it's on page Roman numeral 9.
But is that a It's not an exhibit.
It is from an exhibit with colors superimposed on top of the relevant pieces. So it's from Defendant's Exhibit 5, first page of Defendant's 5. That's in the record at Reporter's Record 213. And the colors in my brief at that location should help show the lay of the land, I hope.
And does that exhibit show where the men were working or where the barrel was that was suspected of causing the fire, or both, or?
It's more 30,000 foot view. It does not show the actual barrels. It's an aerial photograph after the structure has been burned down and debris removed. So it's more to show where the properties are in relation to each other. So Mr. Roberson owns the land. He's the landlord for the land, and he hired these men according to his own admission to clean up the land adjacent to his property. That decision was voluntary. Nobody required him to do that. It was a voluntary undertaking, a project that he undertook. And as the court mentioned earlier, Mr. Roberson went to the site Friday afternoon. He, according to the trial testimony, when he arrived, they sought to extinguish the fire. Oh no, the boss is here. We better put out these fires. That was how he presented.
So he wasn't aware that they were burning?
He was, Your Honor. It was his testimony that he didn't know, but there was definitely contradictory testimony, including from the workers, including from Mr. Just a second. According to Bernardo Ruiz, they had been burning in the barrels for the 2 to 3 days prior. And that's in the record at Reporter's Record 178. So
If there's evidence that Mr. Robertson had knowledge that they were burning in the barrels, is that enough to say that is knowledge enough, or does he have to have control over how they're disposing of the wood and waste?
I don't believe that knowledge alone would be enough, Your Honor. There has to be an employment relationship. There has to be some degree of control over the way in which the tasks are performed, the typical respondeat superior analysis. And so but this is back to direct liability, not even respondeat superior. He went and inspected the barrels and he assessed their cleanup work himself. And that's in volume 1 at 235 through 236. They then left, including Mr. Robertson. They then left the premises with the barrels apparently still on fire. They left them unattended over the weekend. Now that includes Mr. Robertson. Mr. Robertson was there looking in the barrels. It's Friday afternoon. He then leaves and leaves it unattended.
Well, did they pour 5 gallons of water on it before they left? Or was that in?
It's the same time, and it was upon his arrival, according to the trial testimony. They tried to put some water in the barrels, a 5-gallon bucket of water, which was woefully inadequate. So he left the barrels still smoldering, and he was issued the citation for unpermitted burning. The ticket was issued to Jerry Robertson individually by the fire marshal after they conducted their investigation. He was cited for burning in the city without a permit. The testimony at trial was that we required permits because that allows the fire department to be involved. It allows the fire department to be there or to put certain safeguards in place that are going to make sure that nothing like this happens. For example, constant monitoring.
Any evidence disposition of that accusation?
No, Your Honor, I believe that the ticket didn't go anywhere. It just sat. It sat.
Opinion as to valid.
It was the fire marshal's opinion as to a violation. It was his conclusion after his investigation, but the ticket was not adjudicated. Best I can tell.
So what evidence is there?
The issuance of the citation itself it is not that probative. The fact there is a citation, I'm not relying just on that. It is the fact that that was the result of a long investigation. That's what's probative, is that it shows his conclusion. So I'm not relying solely on the issuance of the citation to establish liability that would get us there. But it was the conclusion that Mr. Roberson did unpermitted burning, which is why we're here today. So Mr. Roberson is liable, we respectfully submit, for his own tortious conduct, not just the conduct of his employees. With regard to vicarious liability, Mr. Roberson did exercise control over these folks. He kept them busy. These were his handymen. Whatever he needed doing, they would do it. If he had a roofing job, they could put a roof on a house. If they weren't busy with work, he might have them go do something in his own house to keep them busy, keep them employed. Mow my lawn, doctor my cattle. These are the sorts of things that show an ongoing relationship, control, and that these people were working at Mr. Robertson's behest. Additionally, there was testimony from one of the three workers, Mr. Ruiz, volume 1 of the record, page 168 through 189. He testified, Mr. Ruiz, how do you know Mr. Roberson? I worked for him. This is on direct. And then the lawyer says, you worked for him? Witness nods head up and down. Did you work for him around 2013? Yes, sir. And during that time period, did you work only for Mr. Roberson? Yes, sir. That is definitely more than a scintilla of evidence that he was working for Mr. Roberson. And when you combine it with the other things, Mr. Roberson's statements to law enforcement, the fact that he was cited, the fact that he owns the property, the fact that he controls these men day in and day out and keeps them employed, it all adds up to being not only legally sufficient evidence, but factually sufficient evidence. And so we ask the court to overrule the first issue and to hold in favor of affirming the judgment. With regard to the second issue, is an attack on expert witness opinions. I would point out, Your Honors, that there was no Daubert motion. That there was not a timely objection at the trial court to the reliability of their opinions. There was no effort to strike their opinions as being unreliable. Therefore, there was no ruling by the trial court. There was no adverse ruling that the appellant now appeals. And so I'm a little bit confused about this issue, how it's before the court. I've argued in my brief that that error has not been assigned, and we're asking the court to overrule that ground. With regard to the opinions themselves, though, they were the result of these men going out there and getting their hands dirty, going out there and making observations, looking at the burn marks on the ground and on the telephone poles and on the walls. They saw a burn pattern coming directly from the barrel in the shape of a V. At the point of the V is the barrel. And so it is not accurate to characterize their opinion as speculative. It was based on scientific method. With regard to the third issue, there was sufficient evidence to support the finding of negligence. As I mentioned earlier, Mr. Roberson was sued for failing to ensure the property was safe, failing to properly supervise his employees and exercise control over it. He was present on the 15th, that's Friday afternoon, and he personally inspected the barrels, left them unattended, and that was his negligence. That is an issue there. His breach of a legal duty to be careful to his neighbor. And so there is ample evidence to support the trial court's finding of negligence. The testimony in the trial court was that You can't put out a 55-gallon barrel with a 5-gallon bucket of water. Doesn't work. That's not nearly enough water. The fire department had to bring a fire engine out and direct their hoses on that barrel to put it out. But as Your Honor pointed out earlier, that wasn't good enough. Even that wasn't good enough. A whole week later, the following Friday, they determined that the barrel is still on fire. So this idea, well, we poured a bucket of water on it and then we stirred it to make sure it was out. It doesn't get there. And that's
Assuming there's no third party intervention.
Your Honor, with respect to that theory, the trial court had every opportunity to consider that theory and rejected it, just like the investigators did. Mr. Roberson, the evidence showed the very next day is starting to get on the phone and trying to be proactive. Well, did y'all know about these vandals that have been around on my property? Might have been them. I would respectfully submit that he knew that liability might be attached and that he was trying to find a scapegoat. And the investigators saw right through it and the trial court saw right through it. And I would submit that there has not been any evidence that it was a third party.
Well, he
Additionally,
knew that there had been prior instances of vandalism, and he left the barrels unattended.
yes, and that person who had been guilty of that vandalism, it's my recollection, the record would show that he had been arrested, that there had been an arrest made out of that. And so,
But would a landowner not have some, or Mr. Roberson in that position not have some responsibility, knowing that that had happened before, to take some type of action to prevent it?
certainly doesn't provide an excuse. If anything, it elevates the duty of care. With regard to this theory, though, we had to prove it was more likely than not that Mr. Robertson's negligence or the negligence of his employees caused the injury. We were not required to prove beyond a reasonable doubt. We were only required to prove by preponderance of the evidence, and the evidence supports the trial court's finding that that burden of proof is met.
What's your response to opposing counsel's argument that it was your expert, or was your burden as the plaintiff to put on evidence that ruled out potential alternate causes of the fire? And I'll ask the question that we asked a while ago. Is that your obligation as part of proving causation of the case? Is that an affirmative defense or an inferential rebuttal issue, or where are we on that question?
Based on my understanding of the law, Your Honor, it would fit within the burden of proof that is on us as the plaintiff to establish breach, causation, and injuries. As far as whether the expert opinion was reliable, I think that needs to be the subject of an objection. That should be the subject of a Daubert motion or an objection at trial, not something raised for the first time on appeal. And so the answer to the question, Your Honor, is that burden is within our burden of proof to prove our case. But as far as alternative theories, that's something that should have been brought up before. And with regard to the fourth issue, it's challenging the sufficiency of the evidence on causation. As I mentioned earlier, burning ash in a 55-gallon drum will continue to smolder for days. That's clear from the timeline in this case. Mr. Mize testified that the 5-gallon bucket would be, quote, not even close, would not make a dent, end quote. And that's on page 56 of volume 1. So the burn barrels also had holes in the bottom. I tried to include some pictures of this in my brief to make it easier for the court to find those pictures. But these barrels aren't solid barrels. They're barrels with little vent holes at the bottom. In the record, there is pictures of ash on the ground having fallen out of one of those vent holes. Clearly, this fire was caused by the burning of the trash in those barrels and failure to exercise ordinary care to make sure that your neighbor's property doesn't burn down. And so at the end of the day, we respectfully submit that this case is pretty simple. We have to be careful not to hurt our neighbors. And we're asking the court to affirm the trial court's judgment. And thank you very much for the time. I'm glad to be back in the courtroom. Thank you.
Thank you, Councilman.
With respect to the expert testimony, Roberson properly preserved error. The Texas Supreme Court has many times said conclusory or speculative objections do not have to be, or conclusory or speculative expert testimony, you do not need to raise an objection in the trial court. It can be brought by bringing a sufficiency challenge to the evidence. And because this was a bench trial, Mr. Roberson properly preserved error by raising it in his appellate brief. And
What
so,
about with regard to Mr. Garcia's argument that the evidence shows the point of the fire follows the V from the point of the barrels to, I guess, ultimately to the burn site? I'm not sure where we end up there. Doesn't that constitute some evidence that may not even make it necessary to have expert testimony?
no, because all that does is establish where the fire started near. It does not establish who did it. And so just because you have evidence of location does not necessarily give rise to evidence of who started the fire. And for proximate cause, in order to find proximate cause, you would have to infer inference upon inference upon inference that is no more probable than the other inferences. Inferences that the three workers did not use a sufficient amount of water to extinguish the fire in the barrels, despite their testimony to the contrary. You have to infer that those barrels did continue to smolder, not only on Friday, but all day Saturday, Sunday, Monday evening, for at least 50 hours and more, despite there being no testimony concerning how long it would take for a barrel to fully burn out and cool. And then you would also have to infer that the workers approximately started the fire, even though there was more ash in the barrel on Monday than there was on Friday.
For those inferences or the trial court making determinations of credibility of witnesses?
No, because if you take away the three workers' testimony, then, and if you take away Mr. Roberson's testimony, there is no testimony, no evidence that those barrels were 3/4 full on Friday afternoon. And the plaintiff does have to have some evidence. I'm going to go back and talk a little bit about alter ego. Shackelford's counsel said that, talked about injustice. However, injustice has a specific meaning in the alter ego context. And in the alter ego context, injustice specifically means committing crimes, committing fraud, evading existing obligations, or monopolization. So you have to find one of those specific things.
Would the issuance of the ticket be evidence of?
I was thinking it would not. Well, first of all, Mr. Shackelford did not plead negligence per se. The citation itself was not admitted into evidence. We hear that it's burning without a permit, but the actual statute or city ordinance was not read. are not cited, so we don't even know what the actual statute or city ordinance says. So I would say it is not evidence of negligence. And then with respect to direct liability, Shackelford's counsel, in response to the direct verdict, specifically said the only theory which my client has pled in this case is vicarious liability, respondent superior. And then in his closing arguments, he says the employer is vicariously liable for the torts of his employees. In the trial court's findings of fact, it said 1 bucket of water is insufficient to extinguish the fire in the barrel. There was nothing about Harry Robertson's lack of supervision. So, thank you.
Thank you very much. At this time, I will be submitted to the court on brief and argument of counsel, and we will vote by you in court ruling. We appreciate you being here today and being part of our progress back to live arguments and participating in oral arguments here today. We thank you and wish you safe travels. Hopefully,